delighted to have a Professor David Law, a professor with the Hong Kong University. As you all know, we are here to celebrate our Constitution Day. Every year, 26th November is being celebrated as our Constitution Day. Earlier, we used to celebrate as a Law Day. And in that context, we are delighted to have Professor Law with us on when we are celebrating Law Day. So it's a matter of great honor for us. In a very short span of time, Professor David Law has accepted our invitation. We all know Professor David Law as a great scholar of comparative constitutional law, and he has contributed profoundly when it comes to the constitutional jurisprudence in South Asia is concerned. So friends, when we are celebrating a Constitutional Day, I welcome all of you to this event. Friends, as we all know, the Constitution of India is a cornerstone of nation, and it is the heart and soul of Indian democracy. It is a living organic document, transforming individual, social, and national life in each passing day in the most amazing way, and at least in the recent past. So friends, contrary to the belief, which was a popular belief at one given point in time, that this Constitution of India, which is a document written in English language and created by the elite consensus, may not have a much impact on the majority of the population of this country. But contrary to this belief, this document has been impacting and transforming daily the individual lives and the lives of citizens in the most profound and the lasting ways. And in this context, I'm reminded of a quote, said by a great scientist, Albert Einstein. And he said, "The strength of the Constitution lies entirely in the determination of each citizen to defend it. Only if single citizen feels duty bound to do this and share in his defense, the Constitution survives and the constitutional rights get secured." And in continuation of this, I'm also reminded, and we all pay homage to a great son of this soil, Mr. Professor B.R. Ambedkar, who has been the chairman of the drafting committee of the Constitution of India. And he also quoted in a most profound way that he said that however a constitution may be, if those who are implementing, they are good, it will prove to be good. And however may be the bad constitution, those who are implementing, they are good, it's going to survive and it's going to give the better results. So friends, we have a great duty towards the fundamental law of the land to defend the Constitution and constitutional spirit, constitutional values, and constitutional ethos. So once again, I welcome all of you and wishing you a very happy Constitution Day. And I invite Dr. Molia to briefly introduce Professor David Law for this function. You are on mute, Dr. Molia.
Yes. Good morning, Professor David Law. Professor David Law is a great scholar, as Madam stated, in the area of public law, comparative law, law and social science, judicial politics, and constitutional and political theories. He has served as an UN consultant on legal and political reforms in Vienna and provided a training sponsored by the US State Department to Burmese lawmakers on constitutional reforms. Prior to entering academia, Professor Law served as an executive editor of the Harvard Law Review. He has also earned a PhD in political science at Stanford University. He is a formal Fulbright scholar and has held a fellowship from the National Science Foundation and the Council on Foreign Relations. Professor Low is presently holding the post of Sir Y.K. Pao Chair in Public Law at the University of Hong Kong, where he also served as a member of University Selection and Promotion Committee and the Charles National Chair of Constitutional Law and Political Science at Washington University in St. Louis. Uh, I once again welcome David Law, and I would request Professor David Law to uh, deliver his keynote address on today's Constitutional Day. Happy Constitutional Day to everybody. Over to Professor David Law.
Thank you very much. I have to say that I am honored more than I can say by this invitation. Let me see if I can share the correct screen here. Screen sharing has failed to start. Are you able to see, do you see the slide on the screen?
Not yet, but you'll be able to share the screen.
Okay, I think I'm trying to hit share and it's saying screen sharing has failed to start. I think someone tried to highlight me and maybe that's why I can't share my screen. Let me just try one more time here. What are people seeing? They're just seeing me?
Yes, we can see you.
Okay, so I don't know why I can't share my screen. Let me try this again.
Yes.
Okay, so now let me do this. Okay, so you see the screen, right? Just the slide?
Yes, yes.
Okay, very good. So let me just start by saying it is a tremendous, my thanks to Dean Purvey for the great honor of being able to celebrate Constitution Day and 70 years of the Indian Constitution with you. And I very much hope to have the honor and the pleasure of being able to join you in person someday. Obviously, circumstances do not permit this year, but I promise to have something ready for that happy day. From an outside comparative perspective, I can tell you that there are few constitutions in the world more widely studied by scholars than the Indian Constitution. In the field of comparative constitutional law, we refer to the Indian Constitution as one of the usual suspects, one of the constitutions and countries that everyone studies, along with some obvious ones, the US, Germany, Canada, and South Africa. There are a number of reasons for this attention. It's partly due to the unusual length and scope of the Indian Constitution. It is the world's longest constitution, which means that there is much of interest and much to study in the Indian Constitution. But it is also thanks to the rich body of case law that the Indian Supreme Court has built up. For example, cases about the scheduled groups and the creamy layer are widely read in other countries. But perhaps nothing from India receives more attention than the line of cases from Golak Nath to Kesavananda Bharati, the state of Kerala, to Minerva Mills, that gave us the basic structure doctrine, which I think you all know better than I do. The notion that constitutional amendment can be struck down as unconstitutional if it contravenes the basic structure of the Constitution and therefore cannot be characterized as a mere amendment. So this idea, this Indian innovation, has taken on a life of its own and lies at the core of today's lecture. Today's lecture is based on a chapter in a book that I will say more about later. There is a considerable amount of confusion surrounding judicial review of constitutional amendments, and I think a lot of misguided argumentation. And I hope to be able to clear some of that up. In particular, I hope to show that judicial review of amendments, although still controversial, is not as radical as it once was. First, its growing popularity shows that it is increasingly accepted. And in particular, it is now part of an increasingly common judicial toolkit for defending democracy and promoting democratization. Second, other countries have actually pushed beyond the basic structure and judicial review of constitutional amendments. Judicial review of amendments is no longer the extreme. And I hope to illustrate both points by exploring the experience of post-democratization in Taiwan. Okay, so let's start first with some basic definitions. First, the distinction, these are concepts that we see frequently in the literature on comparative judicial review. I'd like to start with soft review and hard review. So soft review is the idea that the court reviews legislation for its constitutionality, but the legislature has some kind of ability to override or respond to what the court has done. So it could take the form of a formal provision in the Constitution that gives the legislature the power to override, such as in Canada. And that means that the court can strike down a law, and unless the legislature acts, the law is invalidated. Or we can switch that around. There are countries such as New Zealand, where the default is that the law remains in force. The courts can announce that a law does not comply with the New Zealand Bill of Rights, but the law remains in force unless and until the legislature chooses to act. But either way, we call this soft review because there is formally an avenue or mechanism for the legislature to allow the law to stand or to reinstate the law if it so chooses, without the need for a constitutional amendment. Now, hard review, we see in places like the United States and Germany, where a court can strike down a law as unconstitutional and the legislature has no formal override power. We have to qualify that by acknowledging the possibility, which again, Indians are very familiar with, that the legislature could respond by amending the Constitution itself. And if the Constitution is amended, then it becomes difficult to argue that the law is still unconstitutional, unless you have some way of striking down the amendment itself. And that brings us to judicial review of constitutional amendments. And here, I think to clarify a lot of what's going on, one of the things that has happened in the literature is that people kind of have used the basic structure doctrine as a shorthand for all forms of judicial review of constitutional amendments whenever the court is striking down a constitutional amendment. But it's very imprecise, I think incorrect, to refer to all judicial review of amendments as basic structure review. So I'd like to draw two distinctions between the type of review or the type of limit that is imposed on amendment and the effect of the review, right? So first, the types of review that we see, so not all review of constitutional amendments is substantive. It's not always about, well, this amendment contravenes the basic structure of the Constitution, it amends the spirit of the Constitution. Sometimes the review is just procedural rather than substantive. Also, not all review is doctrinally based. You don't always have a court that has to say, well, we have the power to compare amendments against the basic structure of the Constitution. Some constitutions, many constitutions expressly give the court the power to review amendments. South Africa is an example for the South African certification of their interim constitution. So we have both procedural and substantive review of amendments. We also have both textual and doctrinal review of amendments. Textual review, what Yaniv Rosnai refers to as explicit unamendability, is when you have a language that purports to restrict or prohibit certain amendments. And these clauses are often called eternity clauses, right? So for example, the United States Constitution says that each state shall have 2 senators unless all of the states agree. And that is a limit on the rules that otherwise apply to constitutional amendment, okay? Likewise, the permitting the importation of slaves, that provision, the Constitution said you cannot amend this provision before such and such a year. So those are examples of eternity clauses. Then you also have doctrinal limits on constitutional amendment, where, let's see here, this is an implicit unamendability is what Yaniv calls this. And the basic structure is an example of this, where there's no explicit prohibition on amendment in the Constitution, but a court finds that implicitly some amendments cannot be permissible because they are too fundamental to be styled as amendments. In effect, the court is fashioning and enforcing a distinction between amendments and replacements of constitutions. All right. Now, on top of this, I want to add a couple of distinctions that one does not actually find in the literature yet, but I think it's important to understand, and this will help us to understand why it's sloppy and inaccurate to describe all doctrinal review of amendments as basic structure review. So we can distinguish between what I would call protective or rearguard review of amendments and transformative or vanguard review of amendments. So what I call protective or rearguard review, the idea here is, so the basic structure doctrine and likewise the substitution of the Constitution doctrine in Colombia, all of these doctrines share in common. So in India, the basic structure doctrine was employed by the Supreme Court, as you know better than I do, to protect property rights, to prevent the elimination of rights the court viewed as fundamental from the Constitution. And in Colombia, constitutional amendments to extend term limits for the president were struck down on the grounds that they endangered democracy and thus amounted to a substitution of the Constitution. Now, sometimes though, the point of reviewing constitutional amendments is not to prevent transformation or replacement of the Constitution, but instead to clear the way for constitutional transformation. The Constitution isn't what you're trying to protect, but it's what's standing in the way. The basic structure is designed to enable courts to protect the existing constitutional order. But what if, for example, you have a country that is transitioning from authoritarian rule to democracy? This was the case in South Korea in 1987. It was the case in Taiwan in 1987. And you have a constitutional court that wants to facilitate this transformation. Well, the basic structure doctrine isn't going to help you, because if you enforce the basic structure, what you are doing is ensuring the country remains stuck in authoritarian rule. And so if you're going to strike down amendments that threaten to entrench the authoritarian order, you cannot use the basic structure doctrine, because what you are trying to do is ensure that the basic structure itself can be changed. So in Taiwan, which I'll be discussing at length in a moment, we had a problem where legislators who had already served for decades without being elected tried to extend their term of office even further through constitutional amendment. And that is a tough situation for courts to be in, because they can't justify what they're doing by pointing to the text or even the basic structure of the existing Constitution. What they have to do instead is to appeal to higher level universalistic norms of human rights, democracy, and the rule of law, because what they need is not already in the domestic constitutional system. Okay? Now, with that out of the way, I want to introduce the two debates that, in my view, I think the view many people, define the field of comparative judicial review as a field of study. The first is the debate over what is desirable, hard or soft judicial review, and the debate over the ideal of dialogic review. So the idea here is that some people champion soft review on the grounds that it strikes a happy balance between legislative and, sorry, that should be judicial supremacy, not executive supremacy, but judicial supremacy, by giving courts a chance to rule on the constitutionally of amendments, but also giving the legislature a chance to assert its view as the elected body of the people. And so the idea here is that soft review gives you the best of both worlds, because you have both reasoned judicial decision-making about the meaning of the Constitution, and you also have democratic decision-making playing a role, right? And so it is said that soft review makes possible a dialogue between courts and legislatures. It promotes interinstitutional dialogue and thus enhances deliberative democracy. This is the argument made in favor of soft review mechanisms. The other debate, which is taking up a fair amount of people's space and time, is the idea of judicial review of constitutional amendments. Is it, on the one hand, too extreme in terms of the power that it gives judges and their ability to override the will of the democratic majority? Or is it the opposite? Is it actually a crucial tool or a last line of defense for protecting liberal democracy from populism, illiberalism, and so on and so forth? So again, for example, the case of Colombia, where after decades, Colombia democratized, They understood that one of the threats to democracy in Colombia and elsewhere in Latin America would be leaders who would remain in office for too long, thus crippling the opposition and preventing alternation in power, which healthy democracies need. And so you had a leader who, through the proper procedural channels, had introduced a constitutional amendment that would have eliminated term limits. And the Colombian Constitutional Court said, we have to strike down this amendment. If we allow you to do this, it will endanger, we will not have a democracy, and we will, in effect, have substituted one constitution for another, okay? And so now judicial review of constitution, and we also see in countries like Hungary and Poland and now Hong Kong, the slide from liberalism and or democracy into authoritarianism sometimes is formalized through the avenue of constitutional amendments. And so these regimes that fear backsliding into authoritarianism are looking, these courts are looking for some tool to prevent that from happening. And judicial review of constitutional amendments is now part of that toolkit, right? Okay, so I want to suggest that there are two problems with the framing of these debates, okay? First, are these actually just different versions of the same debate? In both cases, aren't we really facing the same basic question, namely, to what extent should courts have the last word on constitutional questions? To what extent should they be final, such that the legislature can't override them either by legislation or by constitutional amendment? The second problem is that, are these debates actually moot as an empirical matter? Why worry about whether courts should have the last word if it is, as a practical matter, impossible for courts to have the last word? If courts are incapable of having the last word, then why should we spend so much time worrying about whether they will go too far? And my answer to both of those questions, my answer to the first question is yes, these actually are the same debate. They just differ as a matter of degree. And on the second question, no, it is not possible for courts to guarantee themselves the last word on anything. And so perhaps much of our preoccupation with the fear of judicial dictatorship or rule by judges is misplaced. Okay. So why I argue that hard, soft judicial review and amendment review of the basic structure style are really just points on the same spectrum. It should already be obvious that there is little real distinction between hard and soft review if the government can easily amend the Constitution. Right? As a practical matter, if the Constitution is as easy to change as legislation, then the government can always get its way equally easily by making legislation or amending the Constitution. Okay, so in order for hard and soft review to be meaningfully different, you have to have an entrenched constitution. And not all constitutions are very entrenched. Some countries make it relatively easy to amend the Constitution. India is on the easier end of the spectrum. The United States is on the difficult end of the spectrum. But a lot of countries are closer to India than they are to the United States on this question. So now, therefore, because legislatures can circumvent judicial review, even of the hard variety, by amending the Constitution, we might say that amendment review is only truly hard, or maybe super hard, if the court can invalidate constitutional amendments. All right, we might call judicial review of constitutional amendments super hard review. So we have soft review, hard review, super hard review. But here's the thing, even beyond super hard review, there are new frontiers that we're already seeing courts and legislatures exploring, and Taiwan is an example of this. And there is no limit to this escalation between courts and legislatures. One side asserts power, the other side asserts even more power, right? What we saw happen in India in the 1960s is the beginning of the story, not the end, not the logical, necessary endpoint of disputation between courts and legislatures. An extreme case, but not the end point. And again, I will use Taiwan as the example there. So even amendment review does not guarantee the courts can have the final word, because there's no such thing as the final word in constitutional politics. The very word politics implies an ongoing process, a process without end. Insofar as politics itself has no end, it is impossible to say that there is an end or a resolution or a final point to conflict between courts and legislatures, whether it be in India or Taiwan or Israel or Colombia or the United States or anywhere else. This is a logical error. Okay. So what I submit to you is that we can array everything that we discuss in literature and more on a single spectrum. Okay. So at the far left of the spectrum, we have what is self-explanatory, a point where there is no judicial review. Okay. And at the other extreme, we have something I call amendment initiation. But it's important to see that there is no point in the spectrum where courts are all powerful and legislatures are powerless, or where courts are powerless and legislatures are all powerful. Does not exist. Consider, for example, the point of no review. Even if the courts do not claim or purport to exercise the power of judicial review, they still have powers of interpretation that they can use to limit the reach of legislation. They can interpret or read down laws to conform to their understanding of the Constitution. And so the distinction between no review and soft review is actually quite difficult to draw. Yes, when you read down legislation to conform to your understanding of the Constitution, the legislature can, of course, respond. But that's just soft review. So arguably, there's no such thing as a no review point where courts have no power whatsoever. As long as courts can merely interpret laws, interpret legislation, and limit their effect in that matter, you always have some kind of review. If they can do any interpretation and they can introduce constitutional norms into their interpretation, you have some kind of judicial review. At the other end of the spectrum, right, we've customarily thought of substantive review of constitutional amendments based on doctrine, e.g. Colombia, Hungary, and India, as the apex, the high point, the zenith of judicial power. But this too is not true. We will see that there is a further point where the court can effectively order the government to amend the Constitution in the way that it wants, which we might call not amendment review, but amendment initiation. That has already occurred in Taiwan successfully. And that is more than vetoing or striking down amendments. Imagine the power of being able to author amendments yourself as the constitutional court. Okay. So every point on this spectrum, so I want to argue that this idea of dialogue also is meaningless, because every point on the spectrum is in some sense dialogic, meaning that there is always an opportunity or some way for the other institution to respond. It is always possible to escalate. You can go from no review to soft review to hard review, and so on and so forth. And even courts that strike down legislation or constitutional amendments have both harder and softer, non-dialogic and dialogic options for doing so. If as a court I want to strike down a constitutional amendment, I can do it softly by saying, you had insufficient democratic deliberation, you didn't take enough time to think about this, you didn't have the kind of supermajority that one ought to have for a fundamental constitutional amendment, so please do it again. That is a softer way, a more dialogue inviting way of striking down constitutional amendments. So even the review of constitutional amendments can be dialogic. And finally, the spectrum can and does expand. It has expanded because when one institution finds new ways to push against the other institutions find a way to push back. And so we see escalation and expansion of the spectrum. Okay. Let me give a bit of the history of Taiwan here so you can understand how we reached a point where the Taiwanese Constitutional Court not only had to engage in review of amendments, but it had to engage in transformative review, where it was forcing through change rather than preventing change. And at one point, forcing through change meant not only could it not appeal to the basic structure of the Constitution, it had to tell the government how the Constitution needed to be changed. Okay, so Taiwan has a very tangled background. I'll try to do this relatively quickly, but you had in 1946, the Republic of China headed by the KMT, the Kuomintang, was the government of China. And it became enmeshed in a civil war with the Chinese Communist Party. While it ruled mainland China, it adopted the Republic of China Constitution. Okay? Then, pursuant to this Republic of China Constitution, a National Assembly was elected in mainland China. The National Assembly is the popular body that has the power to amend the Constitution. Then, because of civil war, the ROC Constitution was amended by the temporary provisions to deal with the civil war in China. And the KMT declares martial law as it's losing the civil war, and ultimately it retreats to Taiwan. And so now what you have is mainland China so Taiwan, just this island, is still under the control of the KMT and keeps the 1946 Constitution, while the rest of China is now controlled by the Chinese Communist Party. And the KMT in Taiwan maintains the legal fiction that it remains the sole rightful government of China, while the Chinese Communist Party maintains that it is the sole and rightful government of all of China, including Taiwan. All right? And now part of the problem is that you have all of these legislators in the regular legislature and in the National Assembly who are elected from districts in mainland China that are no longer under ROC control. So what to do about those legislators? And those legislators all support the Kuomintang. They all support the KMT. So the KMT wants those officials to be able to continue in office. So what do? But they can't hold elections in mainland China anymore because mainland China is now under communist rule. So what do? They turn to the Taiwanese Constitutional Court and they seek an interpretation of the ROC Constitution that says that the first-term legislators can remain in office until elections can once again be held in areas under communist control and the rebellion is put down. Of course, we all know there's no possibility that the Kuomintang in Taiwan can beat the Chinese Communist Party. So this is pure fiction. And because there's no meaningful possibility that Taiwan can retake mainland China, what we end up with is a Congress full of legislators who were elected once in 1946 and will never stand for election again. And this became known in Taiwan as the 10,000-year Congress, the never-ending Congress. Because thanks to the Taiwanese Constitutional Court's ruling, they could remain in office for the duration of the temporary emergency. That temporary emergency has now been going on for over 70 years. Okay? So the rest of the timeline is quite tragic for Taiwan, which is a vibrant liberal democracy with judicial review, because of its narrative that it is the rightful government of China. The ROC government refuses to accept the UN recognition of mainland China. And so it voluntarily withdraws from the UN and is also ejected. And recognition and the Security Council seats switch to the People's Republic of China. All right, that's in the early 1970s. Not long after that, there is a change in power. Chiang Kai-shek, the longtime ruler, passes away. His son takes over. His son is more tolerant of democratization and dissent. He effectively allows an opposition party to operate. In 1987, he finally lifts martial law, and the process of democratization really begins. Okay, but the problem is that to democratize, the Constitution needs to be amended. And the body that controls the amendment process is this National Assembly that consists of people who were elected decades earlier in China. And they like the existing system because it allows them to maintain power without having to face election. And so they tinker and they tinker and they tinker and they adopt some changes, but then they say, you know what? We need a few more years to finish the democratization process. So as part of these democratizing amendments, they extend their own term. And that, in interpretation number 261, that is, sorry, let me just go back a slide here. Oops. No, that's right. So in interpretation number, so the court does a couple of things, okay? First, in 1990, it orders the first-term representatives to leave office, the so-called old thieves, and it mandates elections for second-term representatives. There is nothing in the Constitution, nothing in the text of the Constitution that enables the Constitutional Court to do this. The Constitutional Court has to dislodge these legislators because if you allow them to choose, they will remain there forever. They are the ones with the power to amend the Constitution, and they will simply refuse to amend the Constitution. So the court orders them to leave, and the only way you can order them to leave is to amend the Constitution. So the court tells the government to amend the Constitution to eject the first-term legislators. And that is what the government does. That is one step, several steps beyond what the Indian Supreme Court did in the basic structure doctrine, right? Even the Indian Supreme Court, I think, it would be hard-pressed to simply tell the government to amend the Constitution. So the government complies. It sets a time limit for the existing legislators. And then, of course, the existing legislators try to extend their own term, despite what the court has ordered. And the court, in interpretation number 499, a landmark judgment, strikes down this constitutional amendment that extends the National Assembly's term by saying, in effect, that it is counter to basic principles of democracy that elected legislators can escape election and extend their own terms, that it's fundamentally anti-democratic, okay? And so that was not the end of judicial review of constitutional amendments in Taiwan, but since forcing through the transformation of Taiwan's institutions into fully and regularly elected institutions, others have requested judicial review of amendments, but the court, having transformed the constitutional order, has now taken a more conservative position and has fallen back. Okay, so what can we learn from all of this? I want to suggest that there are three comparative and generalizable lessons about judicial review that we can draw from the episode of Taiwan. I call them the elusiveness of finality, the ubiquity of dialogic review, and the contextuality of judicial power. First, on the elusiveness of finality and the ubiquity of dialogic review. Again, the concept of dialogue is incredibly popular in the comparative constitutional literature, but judicial engagement with other institutions is always there. Dialogue is not something that happens sometimes. It happens all of the time, in that these institutions are always forced to interact. Courts do not operate in a vacuum independent of legislatures. Legislatures never operate in a vacuum independent of courts. Even when courts supposedly lack judicial review power, they can still shape outcomes, again, through statutory interpretation, for example. And even when courts possess judicial review powers, even when they can review amendments to the Constitution, they still cannot simply ignore other powerful actors. You do not become all-powerful simply by declaring that you are all-powerful. That's not how politics works. Second point here is that for every move, there's a counter move. Courts, as we saw in the fight over the amendment of the Indian Constitution's Article 268 or 368, where the legislature kept trying to give itself more power to amend the Constitution, and the Indian Supreme Court kept rejecting those assertions of power to amend the Constitution. It just illustrates my point here. People in India should understand this better than people anywhere. Courts cannot, by diktat, by fiat, end the ongoing process that is constitutional politics by simply asserting that they have the last word. In constitutional politics, as in any other kind of politics, there is no such thing as the last move, because politics is politics. It is a process that does not end. And no matter what courts may say in their judgments, they are not exempt from this reality. And because politics is a tale without end, because courts and legislatures are always engaged in a tug of war, a push and pull, this means that all judicial review is in some broad sense dialogic in nature. To foreclose dialogue in the sense of acting in such a way as to leave other institutions with no room or opportunity to respond is impossible, because again, that would imply that politics has an endpoint, which it does not, as Indians have seen. Okay? All right, so the contextuality of judicial power. Judicial power in practice can be considerably less or more. Some are given judicial review power but don't exercise it. This was the case with the Taiwanese Constitutional Court for nearly 3 decades of authoritarian rule. The whole time they had the power of judicial review, and they just didn't exercise it. Why? Because the government was authoritarian. They would have lost, they would have been replaced, they might have personally suffered. And then when the time came, when the political situation was right, when the politics were right, the court didn't just exercise the power that it was given on paper. It went far beyond that to demand the adoption of constitutional amendments. And so the point here is that the real power of the court does not come down to what the court says it has. It does not even come down to what the Constitution has. It comes down to the political context. And second, if you're going to win in the arena of constitutional politics, the way you win isn't the strength of your legal reasoning, the integrity of your formalism, the quality of your formalism. What really matters, experience suggests, is popular support. In Taiwan, when the court took these staggering steps of striking down constitutional amendments and ordering the government to adopt amendments, it did so with popular support. And in the face of popular support, there was nothing the government could really do to resist. Okay? In any showdown with other institutions, a court that has the public on its side is in good shape, regardless of such niceties as democratic pedigree or black letter law, or whether the court can say, look, we're adopting doctrine from India that other courts have adopted, so we're not going out on a limb. That's not what really matters. The Taiwanese Constitutional Court could and did go out on a limb because it had the support of the people for democratization. And finally, if the ability to prevail in constitutional politics is a function of popular support, which I argue that it is, courts can sometimes beat legislatures and electives and executives because elected officials don't always have more popular support than courts. Just because they're elected doesn't mean they're more popular, doesn't mean they're more trusted. A robust finding in country after country after country is that courts enjoy more popular support than elected officials. And that certainly appears to be the case in India and has been the case for decades, where many people place more trust in the Supreme Court than they do in the Lok Sabha or in the Prime Minister, okay? So in reality, it is possible to have high legitimacy courts, even if they're unelected. It is also possible to have low legitimacy elected legislatures. Taiwan is an example. Strictly speaking, the National Assembly of Taiwan was elected, but it was a very low legitimacy legislature. The court actually had more legitimacy even though the court was nominally unelected. And finally, the democratic pedigree in the form of being elected is not make or break. Again, I submit to you the example of Taiwan, and I also submit to you the example of the high level of public confidence that the Indian people placed in the Indian Supreme Court. Now, if I may, on the first slide, I gave you the link to this, the full version of this lecture published as a paper. I also just want to introduce that this chapter will appear in a book called Constitutionalism in Context, which should be published by CUP hopefully next year. COVID's complicated things a bit, but each chapter in this book, which is suitable for use as either a textbook or a handbook, combines a topic with a jurisdiction. So you have both a deep study of a jurisdiction combined with a deep study of a topic. So you can use the book either by topic or by jurisdiction. So for example, the chapter that, the paper that I just gave you is this Judicial Review of Constitutional Amendments Taiwan. You can use the chapter to learn about Taiwan or about Judicial Review of Constitutional Amendments or about Judicial Review of Constitutional Amendments in Taiwan. Likewise, if you want to learn about religious and Islamic constitutionalism or Iran, you can learn about either or both by reading the Iran chapter, okay? So, and this is the same book organized by region rather than by topic. And I'm glad to say that over half of the chapter, at least half of the chapters do involve East, Southeast, or South Asia. We have a chapter of Nepal in this book because it's underrepresented. And so with that, I will end the screen share and I welcome your questions and comments. Thank you for your patience and your attention.
Thank you, Professor David Law. Now we can keep the sessions for the interactions. Over to Sukrit.
Yes, ma'am. Yeah. So thank you, sir, for your lecture. And as ma'am has said, we are opening the session for interaction, and all students, all participants who have any questions, may please ask.
And while people are looking at that, I would like to share with you the cover of the book, which I think represents the world in all of its diversity. This will maybe perhaps give people a chance to think about their questions. Let me just share this with you. I think this, if you look at this, you will see that this book represents the Global South in a way that most volumes really do not. Just share this with you. You know, people might object, well, why are over half of the people on this cover from East or South or Southeast Asia? And that's because over half of the world's population is in East or Southeast or South Asia. And you wouldn't know that from reading the comparative constitutional literature. You would read a lot about India, right? And that's fair and justified, but you wouldn't learn anything about China. You wouldn't learn about Taiwan, Korea, Nepal, Bhutan, the Philippines, Indonesia, Thailand. I mean, the list goes on and on and on. So I hope that this book, both in packaging and in content, is a book really for the rest of us and one that's suitable for use throughout Asia. I thought that there was a question, so I'll end the screen share here. Something about soft, what exactly do we mean by hard and soft judicial review? Again, so the examples would be, if you look at, Stephen Gardbaum has written about, I'll just type this in the chat, the new Commonwealth model of constitutionalism. And the other person who's written about this is Mark Tushnet on hard and soft review. Soft review is where the court reviews legislation, but the legislature has an opportunity to override. So in the case of Canada, for example, the Canadian legislature can invoke Section 33 of the Charter of Rights and Freedoms and enact a law, reenact a law, notwithstanding that it has been declared unconstitutional by the Supreme Court of Canada. And it can do so for a 5-year period. And then once the 5 years expires, the legislature has the option of again reenacting the law, notwithstanding its invalidation by the Supreme Court of Canada. Hard review, to simplify even more the simplification that I gave earlier, is when the legislature has no option on paper for bypassing what the court has done, short of amending the Constitution itself. Okay, so hard review is the American system, the German system, right? Where, and I think also the Indian system, where strictly speaking, the court strikes down legislation. The legislature then has to accept the legislation is invalid. But even in that situation, hard review isn't really that hard because, as we've seen in India, the legislature can amend the Constitution itself. That's why I think this hard, soft terminology is misleading and confusing, because hard review isn't that hard. As you've seen in India, hard review can be defeated quite easily. Okay, I hope that answers the question.
Yeah, I think Monarch has some question. Monarch, would you like to ask?
Yes, sir. Sir, in the initiation, like in the starting of the whole slides, the presentation, you mentioned that the Indian democracy or the Indian Constitution or the Indian Supreme Court has a protective form of having its constitution amended. So all it means to say is that by a basic structure, what we seek to protect is the constitution in its spirit. Sir, how do we say that that is not a transformative form of constitution? Because what Indian Constitution has basically done is it has taken up principles of law as its basic structure. As its basic structure, it has taken up, let's say, rule of law, supremacy of the Constitution, all these principles as the basic structure, not exactly taking up an article of the Constitution itself. And it has also transformed according to the needs of the people. Sir, in that case, how can it be said to be a protective constitution and not a transformative in that sense?
I'll try to answer the question as much as I can hear it. It would have to be described as protective in terms of what the court is purporting to do. The court is purporting to find, the Indian Supreme Court is purporting to find these principles in the basic structure of the Constitution itself. It's not purporting to add them. I am not expressing an opinion on whether that characterization is correct or not. I'm accepting that characterization at face value and saying that, assuming that, because ultimately the ultimate arbiter of what is or isn't in the basic structure of the Constitution is the Supreme Court of India, right? That's kind of the problem. So it's sort of a circular problem. So the Supreme Court of India says this is in the basic structure of the Constitution already, number one. Number two, that determination lies solely in the province of the Indian Supreme Court. You can question it, but ultimately the Supreme Court has authority on that question. So then, number three, the Supreme Court then gets to protect what it has defined as the basic structure of the Constitution. So I guess my answer to you is, unfortunately, it doesn't matter what you think is or is not in the basic structure of the Indian Constitution. It's not up to you. I don't know if that's much of an answer. I see quite a few questions coming up in the chat. Do I think that super hard judicial review is really healthy for democracy? And then I'll take on these ones about Hong Kong and Taiwan. Do I think that it is really healthy? You know, I think there are different kinds of constitutional cultures, okay? And, you know, super hard judicial review means that conflict between the court and the legislature has reached a certain pitch, to the point where, you know, the court strikes down legislation, the legislature doesn't accept it, the legislature adopts an amendment to the Constitution, and then the court resists the amendment as well. Is that necessarily bad? I don't know. It depends on the context. You know, I think in some constitutional cultures are very muted and polite and soft, and so a gentle move is countered by a gentle move. And then others are loud and dynamic and conflictual and explosive. And so everything is just pitched at a higher volume. And when you have super hard judicial review, it just means that the conflict between the court and the legislature has reached a higher level of volume. Is that inherently bad? I don't know, because even in quieter constitutional cultures, you still have this dynamic of give and take. And even in louder constitutional cultures, there's no real risk of one side annihilating the other, because neither can never actually annihilate the other in a democratic setting. The problem, I guess, is if things go so extreme that democracy itself is broken and the public no longer determines who will win this dispute between courts and legislatures. And I think that's kind of the situation we have now in Hong Kong, where there's been political conflict between the pro-democracy side and the pro-Beijing side. And the response to that has not been this kind of interinstitutional dialogue, a dialogue between the court and the legislature. It's simply been the application of force to critics of the regime until critics fall silent. It's just been the application of force. So as long as political conflict is resolved politically, I think that's okay for democracy. And I don't see, for the most part, again, I'm not an India watcher, but I don't see political conflict in India being resolved by resort to violence. Incidentally, at the margins, okay, but you know, that happens in the margins, even in the United States, right? You can't, in a country of over 1 billion people, you can't expect that no violence will ever occur of any kind. Nothing systemic. I don't see the Indian government relying on resorting to systemic violence to resolve political conflict. The problem now is that in Hong Kong, the government relies to systemic violence, enforcement of the law only against regime critics. And so the rule of law is an instrument of oppression, and there is no hope for political resolution of political crisis. What we have instead is just a resolution by force and oppression. We have dealt with critics not by accommodating them, by having dialogue with them, but by simply forcing them to be silent. So the views that I'm expressing to you right now, for example, are arguably a violation of the national security law. I'm no longer allowed to, and so I have to deal with people who want to think they're winning a debate with me. But when I say certain things, they say, David, you can't say that, that's illegal. So there is no debate. And I think that answers a bit, what is the road ahead for Hong Kong in overcoming repression? What is the role played by the judiciary? You know, this is a work in progress, right? I think what's disturbing is that Hong Kong is sliding faster than we can make sense of it. Faster than we can have. The data is coming in too quickly and it's too extreme, right? Things are being said and done now that were unthinkable 2 years ago. 2 years ago, if you criticized judges for being partial and biased, the Secretary of Justice would speak for you. Now, judges are being criticized for being too protective of the protesters. And the result is that they're being reassigned to different assignments where they don't decide cases. They're being attacked in the media and the government does not speak in their defense. So there are a few canaries in the coal mine, right? Who will be attacked and in what order? And that tells you how bad the slide into repression authoritarianism is. People you have to watch out for. You have to watch out for what happens to the elections. You have to watch out for what happens to elected democratic officials who are pro-democracy. You have to watch what happens to journalists. You have to watch what happens to academics. And you have to watch what happens to judges. And unfortunately, all 5 now have come under attack just in the last 5 months. So I am unspeakably sad for Hong Kong. But I think the greatest tragedy, and I want to take a moment to say this, I know we're running short on time. I'm sorry that if I'm not, it means I'm not getting to all of the questions. I think one of the greatest tragedies is, one, we take for granted that people support human rights and democracy. What we have seen in Hong Kong is that even wealthy, Western educated elites are happy to oppose democracy because it preserves their power and their privilege. This was true in British colonial times and remains true now. The commercial and business interests in Hong Kong have always ruled in collaboration with the government. The government enables landowners to become incredibly rich, and in exchange, the landowners support the government. Hong Kong has some of the highest housing costs in the world, and that is because of the Crown's monopoly on land and how private developers and the rich, the wealthy of Hong Kong share those benefits from the regime. So these people feel that as long as there is no violence in the streets and they can continue to make money, that is the best form of government, even if it means that peace is secured through repression. And these are people who were educated in the West, in Canada, in the United States, in the UK and Australia. They often hold foreign passports, but in the name of patriotism, the Chinese government, they support the enforcement and prosecution only of regime critics and never of the police. And they say that all of this is justified because it restores peace and order to Hong Kong. And the problem is that a lot of people are susceptible to the argument that what matters more than anything is stability, even if stability is secured through oppression. So those of us who support democracy need to be prepared to meet head on the argument against democracy. The argument against democracy is that there are other things that matter more. We want food on the table. We want to walk down the streets feeling safe. And if you can provide that, the other stuff doesn't matter. Civil rights, political rights, these are just the things that these marginal intellectual types care about. It's only for professors. It's only for journalists. It's only for politicians. What the rest of us want is food on the table and security when we walk down the street. Give us that, and we don't care about the rest. We have to meet that argument head on. And sadly, India is used as the argument against democracy in China. I use it. The Chinese will say we cannot have democracy because if we have democracy, the society will break down. A large, diverse society like China cannot hold together. And people like me say, well, look at India. India has remained, for all of the challenges that India faces, it has remained a constitutional democracy since its founding in the face of often grinding poverty, social and political inequality, tremendous challenges, secessionist impulses throughout the country. It has held together without large-scale violence. And do you know what the Chinese response to that is? Shall I be entirely frank? The Chinese response to India, which I think is the best argument that constitutional democracy can work even for developing countries, even for diverse countries, even for countries that face challenges of the magnitude of India, is they consider India a failure. And they say, we don't want to be India. If India is what it means to be democratic, we don't want to be India. This is what they say quietly behind closed doors. They don't say it publicly, but this is what they think. For them, India is the reason they should not be a constitutional democracy. So I submit to you that in the growing conflict with China that we're seeing now, India needs to take a position. It needs to understand what is at stake. Chinese view the Indian system with contempt. Thank you. I feel sorry for Hong Kong too.
Yeah. Thank you so much, Professor David Law. It was great to hear your views. Indeed, we look forward to have you in our comparative constitutional law class. And it would be, we will have a smaller classroom, so we'll have a better scope of interactions with the students at that point in time. And we are looking forward to have you again over here. Thank you, Professor David Law. Over to Supreet.
It is a great honor, and I I'll just say too that I think one of the best things that democracy can do to prove itself is to show that it is capable of providing a rising standard of living. Right? We need to meet people's first order needs. Democratic government has to be responsive to that, and I believe that it is. But it's incumbent on all of us to prove that.
Yeah.
Thank you so much, sir. Now, Vikas sir will lead us into a small pledge that we ought to take on.
I think Professor David Law has some appointment. So
okay,
we thank you, Professor David Law, for your great time. And, when it comes to the constitutional law, we have so many points to discuss and ponder upon, and we look forward to have you again in some comparative constitutional law class. And thank you so much for your time, and wishing you a very happy day ahead.
Thank you, and happy American Thanksgiving as well. And I know it's a little late, but happy Diwali.
Thank you. Thank you so much. Thank you.
So happy Constitution Day to all of you. I request you, sir, please share the screen. On the screen, please share the fundamental duties. As you all know that the fundamental duties has been given.
Fundamental duties, sir, not pledge. Yes.
As you all know that the fundamental duties have been given in our Constitution in Part 4, as Article 51A. There are 11 fundamental duties given in the Part 4A of the Constitution. And you all know that the theme of this Constitution Day is the fundamental duty. So on this occasion, we will read together the fundamental duty, which you can see on the screen. And thereafter, we will take a pledge. While taking the pledge, first I will recite, then you will recite after me. So this is the procedure we will follow while reading the fundamental duty and while taking the pledge. So we will start. Now let's start to read the fundamental duties together. To abide by the Constitution and respect the national flag and the national anthem, to cherish and follow the noble ideals which inspired our national struggle for freedom, to uphold and protect the sovereignty, unity, and integrity of India, to defend the country and render national service when called upon to do so, to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to the dignity of women, to value and preserve the rich heritage of our composite culture, to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures, to develop this scientific temper, humanism, and the spirit of inquiry and reform, to safeguard public property and to observe violence, to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement, to provide opportunities for education by the parent or guardian to his child or a ward between the age of 6 to 14 years as the case may be. So now, after reading this fundamental duty together, now we will take a pledge on this Constitution Day. So while taking the pledge, I will read first, then you will recite after me. I, as a citizen of India, affirm my faith in the universal principle of civilized society, namely that
every dispute
between citizens or groups,
between citizen or groups,
institutions or organizations
institution or organization
of citizens
of citizen
should be settled by peaceful means and
and
in view of the growing danger
in the view of the growing danger
to the integrity
to the integrity
and unity of the country,
and the unity of the country,
I hereby
pledge
myself
myself
never to
never to
resort to physical violence
resort to physical violence
in the case of
in case of
any dispute,
any dispute,
whether in my neighborhood
whether in my neighborhood
or in any other part of India.
or in any other part of India.
Thank you for taking the place. Now over to Sukrit sir.
Professor Dr. Pokhriyal, Dr. Takesh Mallya, fellow faculty colleagues, students and participants, thank you for attending this lecture on Constitution Day. On this Constitution Day, it serves us well to learn from the comparative legal studies and to learn about how other countries have been dealing with constitutional amendments and have been trying to give their constitution a life which serves their country and which serves their socio-political and legal requirements. One thing I found very as just as a leaving remark, that we saw Professor Law talking about the ubiquity of dialogic process, that whenever we are dealing with judicial review of constitutional amendments, there is always a dialogic process. Do we stop at that point, or do we try to make that dialogic process more informed? How do we, if the dialogic process is indeed ubiquitous, then it falls as a duty upon us as participants in the legal sphere, whether we turn out to be lawyers or judges or teachers or administrators in teaching or other administrators as well. So how do we make that dialogic process more informed? How do we inculcate that dialogic process with constitutional vision, with constitutional vision on justice? That could be the further step that we could be taking, so as to have a more constitutional culture ingrained in our society. So thank you for attending this lecture, and thank you all.
Thanks.
Thank you, sir.
Thank you.
Thank you.
Thank you, sir.
Thank you, sir.